All right, Unit 3. Tonight we have chosen for you question 3. What are the major differences between the adversary and the inquisitorial systems of justice? What procedural guarantees embedded in the U.S. Constitution protect the rights of an individual accused of a crime? Evaluate the arguments advanced by critics of the adversary system that it is costly, slow, and should be replaced by the inquisitorial system. You may begin.
The United States primarily uses the adversary system to achieve justice. This system pits two parties, the prosecution and the defense, against one another in order for the best arguments to arise. The belief that competition produces the best result is ingrained in many of our founding philosophies, as seen in our free market economy and constitutional checks and balances.
The alternate form of justice, used by much of the rest of the world, the inquisitorial system, emphasizes the discovery of truth in order to uphold the rule of law. This truth is sought by a theoretically neutral third party that should have no incentive to conceal information.
Like much of our judiciary, the adversarial system was borrowed from English common law, and many of the procedural guarantees in the Constitution ensure its fairness. Article 3 and 6th Amendment rights to a trial by an impartial jury are most exclusively adversarial, but the right to an attorney and indictment by grand jury are also important.
Other procedural rights found in Article 1, Section 9, the right to habeas corpus, and the 4th, 5th, 6th, and 8th Amendments include the right to confront witnesses and rights against excessive bail, double jeopardy, unreasonable searches and seizures, and self-incrimination. The Supreme Court has affirmed the use of an adversarial system by incorporating many of these rights considered fundamental, such as the right to a jury trial for serious crimes in the 1967 case of Duncan v. Louisiana.
These rights protecting the individual are essential to curbing the intensity of the competition in an adversarial case and to ensuring fair proceedings. The adversarial system works by setting up a level playing field for a trial to be administered, but the physical member of the judiciary, the judge, acts more as a referee, whereas lawyers hold most of the power of play and the jury holds the power of decision.
Since both parties have so many incentives to win, there is an advantage to concealing the truth. In the words of a former Oregon district attorney, the primary job of a defense lawyer is to extricate almost always factually guilty clients from any responsibility for their acts.
The inquisitorial system, rather than dividing responsibility between the judge, jury, and attorneys, vests all powers in the judge and only a jury in certain cases, and the actual truth of what happened is sought. Since the attorneys have no reputation or financial gain at stake, as it does not matter to a neutral party who wins, they have no incentive to skew or conceal the truth.
The American justice system is criticized for its inefficiency. The accused can be let off because of a technicality, such as not reading Miranda rights to a detained person or illegally obtaining evidence. The inquisitorial system rarely throws out evidence. Cases can also take years to be resolved in the adversarial system. The protection of fairness over truth by procedural guarantees is one of the reasons for the slowness of trials and justice in general.
For instance, the family of Breonna Dennison waited a year and a half until the murderer was brought to trial. Advocates of the adversary system argue that this slowness ensures fairness and deliberation so that the correct conclusion is reached. Slowness also gives the defendant time to prepare an adequate defense. Ample time to prepare a defense was even incorporated in the 1932 Scottsboro case, Powell v. Alabama.
Our system is often perceived as costly because of the requirement that counsel be provided to those who cannot afford one. There are also problems when one side is significantly wealthy than the other and can hire teams of lawyers to win. Because of budget restraints, government cannot sufficiently prosecute corrupt corporations and wealthy individuals.
The requirement of an impartial jury is also costly because jurors must be paid and additional costs are often incurred in order to preserve their impartiality. For example, in the O.J. Simpson trial, the jury was sequestered in a hotel for a year. That trial ultimately cost California $15 million. However, the same costs can be incurred in an inquisitorial system. The Netherlands, for instance, also provides defense attorneys to those who cannot afford one.
According to Professor Hans Kronberg, 88% of crimes are clear-cut in terms of evidence. So ultimately, the advantage of one system over the other based on the arguments of slowness, costliness, or fairness is impossible to determine, because these problems can be traced back to procedures and constructions of the systems rather than the ideals of the systems themselves. Despite differences, both systems are viable options for justice. Thank you. Other questions?
So it sounds to me from your testimony that you totally disagree with Benjamin Franklin's phrase that better that 100 guilty men go free than one innocent man spend a day in prison.
That is not true. We were just, pointing out some of the weaknesses of the adversarial system. And although it seeks to provide procedural guarantees to ensure its fairness, it's also more easily taken advantage of than the inquisitorial system.
The idea that we would disagree with that statement is false, because while the question itself in our testimonies asks us to evaluate the idea that the adversary system is slow and costly, and while that is true, and we do attribute that to some of the procedural guarantees, but without those procedural guarantees, we would have a country, a fascist country, which is completely against all of our founding ideals, all of our natural rights ideas, all of our classical republican ideas.
Didn't you just, though, in your testimony, call someone getting off, as you said, on a technicality when their defense counsel is upholding their constitutional rights? Didn't you just say that that is something that's a problem?
Fairness, of course, is important, but the point is that a lot of times these technicalities are mistakes.
So you think upholding the Constitution is a technicality?
No, I don't. I think what I'm trying to say is that if there is a mistake with the exclusionary rule, then they need to do something to deal with that evidence and take care of, get that out of the trial. But just because there was a mistake made, that doesn't mean that no crime was committed. The throwing out evidence can't result in justice not being.
So we should preserve the evidence if we think the person is guilty, but if they're not guilty, we're not so worried about keeping it in? Is that the argument?
Could you repeat the question?
Certainly. You just said that deal with the exclusionary rule because you want to keep the evidence. If the person, has committed, that doesn't mean a crime wasn't committed. How do we know a crime wasn't committed? How do we know a crime was committed? Isn't that what the adversary system is for?
Right. What I mean is that if there is other evidence that can prove this person's guilt beyond a reasonable doubt, then the trial still needs to be placed off. They shouldn't be let go just because of one little piece of evidence didn't fit in. If there's still a case to be made against them, they shouldn't just walk.
You mentioned the test that we use, beyond a reasonable doubt, and I wonder how can you justify such a high standard of proof in order to get someone convicted?
Well, you have to look at what's at stake there. Beyond a reasonable doubt is a high standard, and it is used because we are potentially sending someone to prison for a very long time, or potentially even putting them to death. So we have to be absolutely sure that a person committed this crime before we punish them so harshly.
Then maybe we should use beyond any doubt.
I believe that would be appropriate to sentence someone to death, because we absolutely want to be sure if the government is going to kill someone, that killing is justified. But I think reasonable doubt is sufficient in non-death penalty cases.
Saying that beyond any doubt seems to me that a problem with a lot of our government is that, as I believe James Madison said, that we're not a society of angels. We're not going to be perfect. So saying that beyond any doubt is unreasonable unless we have time machines or something.
The purpose of beyond reasonable doubt is, well, what it means is that if you asked an average person, there's no reasonably they appear very guilty. And you can't just include crazy conspiracy theories that if aliens landed and blah, 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 then this could happen, and then they may be innocent. Beyond any doubt is a very high standard, and beyond reasonable doubt, I think, is sufficient.
Let me ask you this. You just sparked something for me. You said the average juror. There's a phrase that said, how can we trust the fate of people to a group of 12 citizens who weren't smart enough to get out of jury duty? How do you feel about that, and how does that affect the jury system in that, because the jury system today is that people get off jury duty for a lot of reasons, and so you end up with a skewed amount of people who are unemployed, who have nothing else to do, or older people with nothing else to do.
Where exactly, and there's the question?
Give me your reaction to that as the effectiveness of the jury system. If the situation is that we don't get the average juror? People can get out of jury duty.
There's a lot of people that aren't thrown off the jury because they're not too smart. There's a lot of people that are thrown off the jury because either the prosecutor or the defense attorney wants them off. And for a very long time, that was done by race. For example, if you had an African defendant, the prosecutor would often want to exclude the other African American jurors. And the Supreme Court finally stopped this in Batson versus Kentucky, establishing the Batson challenge, where a defense attorney can ask the prosecutor if he is seeking to remove a juror for racial purposes.
I would also wonder, I don't doubt that that your statement that the unemployed and the elderly are often the ones that end up on jury trials. I would like to see that statistic, but I would also argue that the people that often end up on juries are the people like kids that have taken We the People. I'm excited for jury duty now that I understand the original meaning of it and the original intent behind it, that it was the original way that people could participate in their government. So I would hope that on my jury there's at least 1 or 2 people that really believe in the jury system.
I think it's important to notice that, like Shane was saying, that the juries aren't necessarily made up of an average group of people. Both the defense and the prosecution try to choose people who are going to rule in their favor. And people look at having a jury trial differently because some people think, oh, a jury of my peers, they'll side with me. Others, most people are like, no, we want them to pay, it doesn't matter. And so you see a lot of 95% of felony convictions are settled with plea bargains where people waive their right to a jury trial. So there's some people think a jury is great and others are not trusting of it.
Okay. You're a criminal defendant. Under which system do you want to be tried? The adversarial system or the inquisitorial system?
Although our testimony may have said otherwise, I would much rather be tried under the adversarial system. Because in an adversarial system, it is as if the prosecutor is bringing the case to court and has to prove to the court, which includes the jury and to some extent the judge, that you are guilty beyond a reasonable doubt.
Sometimes the judge.
Sometimes the judge. And you have the right to make a statement that could possibly tell your side of the story and prove that you are not guilty. Both sides have a chance to present their case, tell their side of the story. Whereas in an inquisitorial system, the judge has all these documents and the police collected or something like that, and he's asking questions to the prosecutor or the defense attorney. They don't really get to speak up and say whatever they believe they need to say. It's up to the judge.
I would also rather be tried in the adversarial system because the fact that in the inquisitorial system, the judge, or in some cases the jury, has so much power that they're leading the investigation and they're bringing the case and they control the evidence and they make the decision.
So as a defendant, you would want those technicalities at this point?
Yeah, of course. But I think when you have one person with all these different powers, there's a potential for corruption. Like in our government system, we see like separation of powers in order to limit government, and I think that takes place in the judicial system too.
Unfortunately, which system I would pick would depend on the status of my bank account. Because if I can't afford a good enough lawyer, or if I can't afford a lawyer at all, then I don't want the state defending me, because oftentimes there are lawyers that simply aren't paid enough or have too many cases taken on. That was the one of the issues behind the, I think it was Thomas case decided last week, that the lawyer was only being paid a cap amount of $1,000, and he had so many other cases that he couldn't focus on this man's case, even though it was a murder trial and a death penalty trial.
Are there any parts of the inquisitorial system that you like and would bring over into the adversarial system?
Yes, as Gabe just mentioned, the disparity in resources and the idea that one side can have a monetary advantage over the other. In the inquisitorial system, it's more common for a defendant to be able to choose whatever attorney he wants, and the government will pay that attorney a sufficient amount so that the attorney will do a reasonably good job.
Boy, that was a mistake putting Bridget and I on that one.
That's what they needed, so.
Obviously, I'll start. Obviously, the way your testimony is written, you are really inviting that attack that you just got. So you may want to tone that down a little bit or rewrite it a little bit, just so you don't invite such a vehement response. Okay, because you've got, I'm looking at the panel that you've got on Saturday, and you're liable to get a pretty close to that kind of a response. So either be very, very ready for it, or you may want to tone it down a little bit so you can ask some different questions. I have no idea how many questions you just asked. You got asked because we started interrupting you and asking more questions. And that can happen. It's not unheard of. 9? So it is not unheard of that you're going to get interrupted by judges who say, wait a second, what you just said doesn't make sense. So you did a really good job not getting flustered and coming back. A couple of places you could have thrown in some more evidence. Shane, excellent job on throwing in Batson. That was a good place to kind of slow the process down, throw in some evidence, and get back on track with where you wanted to go. So I would suggest all of you want to have one of those go-to cases that you can do that with. A couple of comments. Katie, you said that the attorneys want to choose the jurors who will rule in their favor. The jury system in the United States isn't you get to choose the jurors you want. You get to knock off the ones you don't want.
Yeah.
Okay, so that's a better way to put it is, as a lawyer, I want to knock off the jurors who I don't think would be in my favor, as opposed to choosing the ones I want. Because I can tell you that, and I think all of us at this table will tell you, we never get the jurors we want. We try all we can.
We try really hard, but the other side's trying too. So.
Yeah, so there's always that competition there. I think that Gabe, you made a really good point about the resources and bringing that up. Let me give you something that you can take a look at that is a Nevada standard, and considering you have a justice of the Supreme Court on your panel, probably not a bad idea. Under the Supreme Court rules for criminal defense attorneys, that 2 years ago it was passed what is referred to as ADKT 411. And I know that ADKT 411, which are standards for all attorneys, but especially those in public practice, public defenders, and certain standards of the kind of work they have to do. And so that will go right to the point that you were making, and I think that you can pull some stuff out of there. And so I think that will be of use to you.
ADKT stands for Administrative Docket.
So it was, and it's an order issued by the Nevada Supreme Court. And it was put together by a panel of a committee that the Supreme Court named, and I think Chief Justice Hardesty at the time was the chairman of that.
I thought it was Cherry.
May have been.
I think it was Cherry.
Okay, so, but anyway, that will help you a lot. There is also a phrase, in your testimony, I thought you did a great job. You brought in a lot of examples and you answered the questions. That was really good. There's another phrase that I'll throw out there that I'll end with, which is that the American criminal justice system is the worst system in the world except for every other system out there. And that's very much a truism. There are a lot of problems with our system, but all the other systems are worse. So it's a work in progress.
I'll just offer my congratulations to you. I'm amazed how many hours you must put into this to understand the law better than I do at some of these points. And you did very well. I'm not going to belabor it. I'll leave the rest of the comments to the judge.
First of all, I came at you and you stood your ground, which is what I want you to do. I want you to push back, and you did that very well. If you use the word technicality in your testimony, though, you are going to get that kind of response. Because our system, the defense attorney, represents the criminal, but he also represents the Constitution. When we turned that idea on its head and said, okay, you're the defendant, what do you want? And you told me you wanted those technicalities, they're not technicalities anymore. Those are rights that you are afforded under the Constitution. So just remember that there's really that tension there, and it's something you need to be cognizant of. The other thing that you need to know, just as a technical thing, if the exclusionary rule is invoked and evidence is kept out, that doesn't mean the defendant walks. It means that evidence can't be used. But if there's other evidence, they'll go away. Okay, so that isn't the end of the game unless that's all the evidence there is. Okay? I thought that with the last question, each one of you did a magnificent job. Your answer compared, contrasted, did everything I wanted to hear. That was a great answer. And then Gabe, you followed that up by saying, it's a great system if I've got a wallet. Perfect answer, because it pinpoints one of the real problems that we do have with the system. It's expensive, and if you don't have private counsel, you better hope that the PD that's been appointed for you, or standby counsel, whoever, or outside conflict counsel, whoever that person is, cares about your case. And I'll tell you that the defense attorneys I know are dedicated professionals. So just keep in mind that conflict when you're talking about this, so that you don't have your testimony be completely one-sided. You guys did a great job.
Thank you.